I believe in a thing called LURB. Stop in the name of LURB. I will do anything for LURB, but I won't do that. The possibilities are endless. Welcome to a special one-off episode of Planning Shorts about the new Levelling Up and Regeneration Bill, affectionately known as the LURB. You may remember us from a short series of planning webinars in the darkest days of the pandemic in 2020. My name is Matthew Fraser. I'm a barrister at Landmark Chambers, and I'm joined by 4 other planning barristers for a half-an-hour discussion to give our initial insights on the LURB. And it's fair to say that we LURB it. First, Thea Osmund-Smith of number 5 Chambers will consider the implications of the LURB for plan making. So in summary, she'll be asking the question, can you plan for LURB, or does it surprise you? Next, Ashley Bowes of Cornerstone Barristers will be looking at decision taking, including the revised section 38.6. How do you decide if you LURB someone? Then Hutton of 39 Essex Chambers will tell us about the changes to environmental assessment and historic environment. Sometimes LURB can hurt. After that, for neither LURB nor money, I'll run through the new infrastructure levy to replace SIL and section 106. And then finally, Killian Garvey of King's Chambers will speak about the power of LURB, i.e. post-decision matters, enforcement, as well as amendments and appeals. So starting with you, Thea, over to you.
Thank you. I'm just really enjoying watching Killian's faces as you go through your LURB jokes, but that's brilliant, Matthew. Thank you very much. And on to plan making. Well, how fast can I talk? Because there is a lot here. And the obvious aim is to speed up the process and get more coverage, since only 39% of authorities have up-to-date plans in place. Now, there are provisions for the Secretary of State to intervene literally all over the place, and for local plan commissioners to be deployed to support or ultimately take over plan making if local authorities aren't getting the job done. And I think that's brilliant. I'm imagining a bunch of plan makers in capes and dark sunglasses armed with scale rules sweeping through the local planning authorities of the country. So the process starts with the local plan timetable, and that sets out the timetable for the preparation of the local plan. And if local authorities don't produce that, guess what? The Secretary of State may prepare a local plan timetable and direct the authority to bring it into effect. Now, the expectation is that plans are produced within 30 months. That's quite a tall order given the many, many years that we see the process taking at the moment. The local plan then has to be prepared in accordance with the timetable. And during that process, the local planning authority must seek observations or advice from a person appointed by the Secretary of State and publish those observations. Now, regulations published by the Secretary of State will prescribe how that process works in due course, but essentially these are gateway checks that I think actually will be really useful in identifying showstoppers early on and avoiding a lot of wasted time and expense. Now, plans must have regard to national development management policies, and that's brand new. National development management policies are again designed to help make the contents of plans faster to produce and easier to navigate. And they're policies on issues that apply in most areas, such as general heritage protection, greenbelt, etc. Now, the policies will have the same weight as plans, so that's new. The National Planning Policy Framework is, of course, a material consideration. These policies will have that, that statutory force. And unsurprisingly, they're going to be derived from the National Planning Policy Framework. Now, we're told that the NPPF is going to be refocused on setting out the principles to be taken into account in plan making, and there will be consultation on that in due course. Now, that all seems to me to be sensible and will achieve consistency throughout the country, but I don't actually think it's those well-worn policies on heritage, greenbelt, AONB, for example, that slow the plan making process up. Rather, it's the local, more contentious issues, particularly about identifying needs and sites to meet those needs, which are often the most problematic in the local plan process. And that's what causes the real delay. The duty to cooperate's gone. That will raise a cheer, I'm sure, because the consequences for a plan in failing that duty are enormous. It's going to be replaced by a new flexible alignment test set out in national policy, but that still leaves a fundamental gap, of course, in strategic planning, although 2 or more local authorities may collaborate to produce a joint spatial development strategy governing matters of strategic importance across their areas, if they choose to do so. Two more big changes: a street vote allowing residents on a street to bring forward proposals to extend or redevelop their properties in line with their design preferences. I mean, what is there to say about that? Everyone will have seen the cartoon doing the rounds about the residents that voted to demolish their neighbours' homes. This is not planning, it's pandering, and it's potentially a disaster. Finally, to incentivise plan production further and ensure that newly produced plans are not undermined, the intention is to remove the requirement for authorities to maintain a rolling 5-year supply of deliverable land for housing, where the plan is adopted within the past 5 years. Now, I'm not persuaded that the presence of the tilted balance is in any way a bad thing or has disincentivised plan making. In fact, I think it's probably the opposite. The problem with plan making fundamentally is resources and politics. The failure of a plan to deliver would, of course, still be a material consideration in decisions. But I think taking away a mechanism to ensure that housing can still be delivered when allocated sites are not coming forward will mean that those failings take a lot longer to redress, and that can only worsen the housing crisis. So that's a really ill thought out change, in my opinion, and a much shorter term of protection, perhaps the 2 years that we have for neighbourhood plans, would be preferable.
Thank you, Thea, for that sojourn in the Garden of Delights in housing land supply. I had a question, if I may, which is, well, do you think that these changes to the development plan making process will mean that we'll see fewer developments which are departures from the development plan, thinking specifically of housing proposals?
Yeah, I think probably if what is proposed comes to fruition, then yes, the combined effect of the high bar in section 38.6, which I think you're going to talk about in due course, and the removal of the requirement to demonstrate a 5-year housing land supply, particularly if that's adopted, will undoubtedly have a chilling effect on housing appeals in particular. But I think it's some years off, and there will clearly be those sites which are so clear on their own merits that they will still be granted permission, notwithstanding those changes.
Yeah, interesting. Thank you very much. I'm going to talk now about 3 things quickly: the implications of the changes that Thea outlined for development management, pre-app consultation, and good design. Well, first of all, the key headline point is the amendment to section 38.6, no longer a plan-led system, but a plan and national policy-led system, and a conflict between the development plan policies and the national development management policies should be resolved in favour of the latter. So the obvious question is, well, what are national development management policies? Well, that's a policy of the Secretary of State made in relation to development or use of land in England, which is designated by them by direction as a development management policy. Only, however, after such consultation has taken place as the Secretary of State thinks fit. Obviously, a straightforward and sensible move. It was trailed in the Building for the Future White Paper, and we don't need 50-odd heritage policies or 50-odd greenbelt policies, all slightly differently worded throughout the country. So the next key change is the determination must be in accordance with the development plan and national development management policies, unless material considerations strongly indicate otherwise. It's obviously a change of emphasis, but it will still be, in my view, a matter of judgment for decision makers. There's still no prescribed weight to be attached to the development plan or development management policies, and I think judges are still very likely to defer to the judgment of decision makers absent perversity in the normal public law sense. In practice, coupled with the mandatory design codes I'll talk about in a moment, it should give greater certainty to developers, however, that their project is likely to be approved or not approved. Turn to pre-app consultation. The present temporary powers in the Localism Act, which inserted amendments to section 61 of the Town and Country Planning Act, are to be made permanent. Currently they expire in 2025. Not much use has been made of them so far. It's only in relation to onshore wind proposals of 2 or more 15-metre hub height, where pre-app consultation is currently mandatory, but it seems to signal a step change. The Secretary of State is looking to expand the use of those powers to a wider range of proposals. But again, in practice, many large-scale housing schemes will have pre-app consultation because that's encouraged by policy, Many controversial projects will have pre-app consultation, so query how much change that will give in practice. And the final point is about good design. Well, the government explains in the companion guide to the bill, which was published at the same time, that good design, which reflects community preferences, is, in their view, a key objective of the planning system. There will therefore be a requirement for each authority to be covered by a design code, and that's envisaged to be in a local plan or a supplementary plan, which is a new version of supplementary planning documents, but will be part of the development plan and subject to a lighter touch examination regime. And the purpose of which is to stipulate design requirements for development or particular types of development. But interestingly, the statute, perhaps anticipating some issues that might arise at the examination of local plans or supplementary plans, says two things that don't have to be in design codes. It says there's no requirement to stipulate design requirements for every type of development. So no one leaping up and saying, well, there's no design requirement for a BH storage unit, and no requirement to stipulate requirements for every aspect of design. So again, no one leaping up and saying, we haven't got a design code for all the guttering, design code for the window fenestration. So with that, I'll hand over to Tora to talk about natural and historic environment.
Sure, thanks very much, Ashley. I'm going to, as Ashley says, talk about heritage and environmental assessments. And I'll touch briefly on heritage, because I think there's a bit more to say on environmental assessment. But heritage is currently covered in Chapter 3 of the Planning Bill. And there are a few changes. I'm going to discuss two of the main ones. So currently, we have the Listed Buildings and Conservation Areas Act, which I'm sure, as everyone knows, contains provisions relating to listed buildings and their settings and conservation areas, which requires a decision maker to have special regard to impacts on their significance, in essence. And the courts have said that means giving considerable importance and weight to the significance of those assets. Now, I've always thought it was strange that the statutory protection applied only to those assets, and then the policy protection was much broader. And so one of the proposals in this bill is to add an additional section into the Town and Country Planning Act, which will effectively extend that duty to other assets. So it's now proposed that it's worded slightly differently, but a similar sort of duty will apply to scheduled monuments, registered parks and gardens, World Heritage Sites, and areas designated under the Protection of Recs Act. So seems to be a sensible way forward. I think there will be a need to do similar, or make similar legislative changes in, for example, the Planning Act regime, which also has a sort of piecemeal approach. Only certain assets enjoy certain protection. And the second big change is the introduction of temporary stop notices into the Listed Buildings Act. So an ability on planning authorities to serve those where they consider works are being done in contravention of the Act, and then also an enforcement regime to prevent anyone acting in non-compliance with a notice. But moving on to the environmental assessment provisions, and I think that these have the potential to have quite a significant impact on how we all approach environmental protection. So Part 5 is entitled Environmental Outcomes Reports. And the first point is that essentially all of the sections in that part make provision for regulations to provide certain things. So at the moment, we don't have a clear idea of how this is going to look, because it's all going to come forward in regulations. The second point is this is not a wholesale or necessarily a wholesale replacement of EIA, SEA, and the habitats regimes, but I'll perhaps talk later about how those things interact. So the first thing the Act does is it makes provision for the Secretary of State to set specified environmental outcomes relating to environmental protection. So first point, we don't know what those outcomes are, but environmental protection is defined in the Act, and it's a fairly unsurprising definition. It includes, for example, protection of the natural environment, cultural heritage, and the landscape from the effects of human activity. There's then provision for regulations to be made to require an environmental outcomes report in relation to certain plans and certain consents, so plans and projects. And at first, it looks like this is essentially an environmental assessment mechanism, because there's power to make regulations to prevent any decision being taken on plans and proposals unless and until a report's prepared, and then the report is taken into account in the decision. So very much like an EIA, SCA type regime. But where I think this is different is that the legislation says the regulations may make provision for the assessment of any steps which may be proposed for purposes of achieving those effects, mitigating effects, avoiding effects, or compensating effects. And so one can understand that there is the need to assess that there would be in any ordinary EIA, SCA type proposal or assessment, but there's also provision for the regulations to provide enforcement and monitoring of environmental outcome reports. So what that begins to suggest is that your reports are going to contain required steps, and if you don't comply with them, like a planning condition or something like that, you can then be enforced against. So that I think is a new departure in terms of environmental assessment. The bill explicitly provides that the regulations made must not effectively weaken environmental protection, and that's a matter that Secretary of State has to ensure. Again, I'm sure that's something a lot of people can fight about, because that will be a matter of judgment. And then the regulations may also make provision for authorities to report on how environmental outcomes are being delivered and being achieved. So that's a sort of a whistle-stop tour of what we may see, but as I say, it's fairly unclear as to how this will play out.
Thanks, Tora. Do you think it's going to lead to a simplification of environmental assessment?
Yeah, well, as I say, it's unclear how this will look, but I think first blush, it seems the answer is a clear no. And the reason for that is first, this appears to be an extra layer of assessment or type of assessment, which applies only to certain projects, which will be specified in the regulations. And then the second point is section 127 of the bill sets out that the regulations may provide how environmental outcome reports are to interact with EIA, SCA, and habitats regulations. And what it says is essentially the regulations can make provision for treating something you've done under one regime as counting for another regime. So if you've done a habitats assessment, you can then count it against your environmental outcomes report, or vice versa. And then it also says that the regulations can disapply habitats regs, for example, in relation to certain projects. So we could end up with a real mess of different types of regulations applying to different projects, and there being a number of layers. So at the moment, there seems to be potential for a lot of confusion. But as I say, it'll sort of depend what the regulations do.
Thank you very much, Tora. And I mean, my area, which I'm going to be talking about, the new infrastructure levy, is very similar story, in that a huge amount of the detail is being left to regulations. So we're not going to know for sure what's going on. But I want to just introduce what the proposal at least is, insofar as we know, to replace the current system of developer contributions via Section 106 and Community Infrastructure Levy, or CIL, with this new infrastructure levy. And the aim of the government is to ensure that more of the money that's accrued by landowners and developers goes towards funding local infrastructure. And that the bill sets the framework. And as I said, the detailed design will then be fed through in regulation. So there's only so much we can know at this point. The big innovation of the scheme, it seems to me, is that the levy will be charged on the value of the property when it's sold, rather than being triggered by the commencement of development, as in the present case, and it will only apply above a minimum threshold. And so the levy rates and the minimum thresholds are set and collected locally, just as the position is in relation to CIL. Different rates can be set in an area, again, similar to CIL. However, unlike SIL, the rate will be set as a percentage of the gross development value of the property, rather than being based on floor space. And the idea is that this allows developers to price in the value of contributions into the value of the land, and to allow their liabilities to actually respond to market conditions. So, and that sort of has a twin purpose. Firstly, on the one hand, it removes the need for obligations to be renegotiated if the value ends up being lower than expected, but at the same time allowing local authorities to share in the uplift if the value turns out to be higher than was expected. So there's no more relying on complicated review mechanisms in Section 106 agreements, for example. And the commitment that is in the proposals is for the levy to secure at least as much affordable housing as developer contributions do now, which to me sounds like quite a modest aim. Alongside the levy, the bill will require local authorities to prepare infrastructure delivery strategies, so like the SIL infrastructure list now, to say where the money is going to go, and that will be prepared with input from infrastructure providers. And that there'll also be related powers given to local authorities to determine and impose the portion of the levy that they want to see in kind as on-site affordable housing. I'll talk about that in a moment. There will still be a retained role for Section 106 agreements, firstly to deliver infrastructure that is integral to the operation and physical design of the site, so internal play areas and flood risk mitigation strategies and things like that. And there'll also be a retained role for Section 106 agreements for large, really big sites where the infrastructure will be delivered in kind predominantly and negotiated, but not at a level that's less than would have accrued through the infrastructure levy. So what are the key pointers from it? Well, there's a huge amount that's left unclarified and will need to be resolved. But I think my biggest excitement about the proposal is the contributions more fairly reflecting the value of a scheme. Just seems to be fairer all round in both directions. But my biggest concern at present is about the trigger for the payment of the levy being later than commencement, quite a lot later. In fact, possibly even after occupation, because it's upon the point of sale of the property, which means that a development could be built out and potentially occupied before any levy is due, which I think is potentially problematic. Also, it does create uncertainty over how much will be paid, because it's contingent on the future value of the sale rather than something that's known up front because it's been negotiated in a Section 106 or is clear from the SIL schedule based on calculating the floor space of the property. So I think the sorts of concerns that developers have about late stage review mechanisms, about the uncertainty that this generates, will also feed into the proposals here. And the other question, as I mentioned earlier, there's going to be this ability for local authorities to determine how much of the levy they want to be provided in kind as affordable housing provision. But how does that work chronologically? Because if the value of the levy is only being calculated at the point of sale, then how do you know how much money you're going to have to build affordable housing on site when you're actually developing the scheme? So I think that's difficult to understand as well. And I don't know how that apparent chronological problem is going to be addressed in the detailed regulations.
Over to me then. Just before I start addressing matters, there's just two questions I'd like to ask, if that's all right. So Ashley, could I just ask you, do you think these changes will actually make a difference in practice?
I think there's two answers to that question. One, I think the elevation of national policy to the same status as the development plan in and of itself is unlikely to make much of a difference. As we all know, the framework is highly influential on decision taking already, affect the weight to attach to development plan policies, and can be determinative in the outcome of application. So I think that in itself is unlikely to make much difference. But I think what is likely to make a difference is that if the new development management policies on a national level are uniform and comprehensive, and if the design codes are similarly uniform, comprehensive and clear, then I think developers will have more confidence to invest because they will know that, or have greater certainty that something is likely to be approved if it accords with all of these things. And similarly, they'll know that certain projects are unlikely to go forward. So I think it depends how much time is put into making these documents comprehensive and making them covered, which is obviously going back to a resources question. But assuming they are, well, that potentially could be a very positive thing.
Great. And I suppose my other question for Matthew, do you have a sense how and when these changes will be rolled out?
Well, what we know is that what they've committed to, which is completely understandable for obvious reasons, is that any sites that have been permitted before the levies introduced are still going to be subject to the old regime of SIL and Section 106. As for future sites, it sounds like the plan is to introduce it through what the government calls a test and learn approach. So it will be rolled out nationally over a number of years with ongoing monitoring and evaluation, which to my mind is code for we have absolutely no idea how or even if this is going to work.
Great. Well, I'll talk about my issues then. I'm going to talk about what happens after the grant of planning permission and including enforcement matters. So the first thing I'm going to talk about is commencement notices. Or I should say all the changes I'm discussing essentially involve changes to the Town and Country Planning Act, either amendments of existing provisions or entirely new provisions altogether. And the intention is to introduce a new section 93G to the Town and Country Planning Act, which is for commencement notices, which will require all developers to provide a commencement notice to the local planning authority before the development begins on all occasions. If they don't, the local planning authority can serve a notice on the developer requiring the information. And if the developer doesn't do that, then there's a criminal offence occurs. But there's no if the developer doesn't actually provide a commencement notice and the local planning authority don't say anything to them, at the moment, there's no recompense. So it made me wonder what does the point of this? And I suppose presuming people do actually comply, it will help local authorities with monitoring and understanding their fibre supply. There might be an enforcement angle where they say you didn't implement when you say you did, because you didn't give us a commencement notice to that effect. And also there might be some overlap with SIL, the Community Infrastructure Levy, where of course there is currently commencement notice that are required, or it might have some overlap with the issues you're discussing, Matthew. So that's commencement notices. There's also the suggestion of introducing completion notices. So where a planning permission has been implemented, but you're outside of the lapse period has run, the local planning authority can serve a completion notice on you, which will specify a reasonable period during which you've got to have completed the development. It's a minimum period of a year. And if you haven't completed by that period, effectively the permission ceases to have effect. Any development you've done up to that point will still be regarded as lawful, but anything done after that, you can no longer rely on the planning permission. There is a right of appeal against that. There are three ways you can appeal against that. You can either argue you weren't served with the notice, you can argue that you will complete in a reasonable period, or you can argue that you need longer than they've specified. That second ground, saying that you will complete in a reasonable period, I'm failing to understand why that exists, because of course, if the local planning authority say you've got to complete in 12 months, why would you appeal to say, well, you didn't need to serve me the notice because I will complete in 12 months? Unless I'm missing something, it's a rather redundant ground of appeal. And the only other thing to say about these completion notices is that will apply from the moment that the bill becomes law. So it could apply to permissions that are being granted today. The next thing to talk about after planning permission has been granted is the way in which you can amend a planning permission. So there's going to be a new mechanism altogether to amend planning permission, which is a new section 73B to the Town and Country Planning Act. It's under the title minor variations, but the power effectively allows you to identify an existing planning permission and say, I want to get a new planning permission that is not substantially different from it. So obviously you've got section 73 now where you can change your conditions, and you've got section 96A where you can do non-material amendments. This is a new power where you can do minor variations to a planning permission. And the last thing I'm going to talk about is enforcement, where there's a number of changes that are being proposed to enforcement powers. They all, to the most part, help the local planning authorities and are onerous to those people who are breaching planning control. The first one, which is a big one, which is that the immunity principles, 4 years principles being abolished altogether. Now it's 10 years across the board that you need to be able to demonstrate before your development becomes immune from enforcement. 4 years obviously attached in respect to certain material changes of use to residential dwellings and indeed operational development. It can sometimes, it would delight and excite lawyers as to whether the 4 or 10-year principle applies, but the government are depriving us of that fun. And now it's going to be 10 years across the board. The local planning authority have new powers. They can serve enforcement warning notices where they think that there is a breach of planning control, but they think there's a reasonable prospect that they would grant permission. They can serve an enforcement warning notice, and this effectively stops the clock in terms of garnering immunity, which oftentimes the local planning authority are aware of a breach. They're not hugely concerned with it, but they want to regularize it. But that can take time. So they could serve an enforcement warning notice, and that would stop immunity from being achieved whilst they are negotiating with the developer to actually resolve the issue. The local planning authority now temporary stop notices. Currently it's 28 days. The proposal is to extend that to 56 days. In respect to planning appeals, the Secretary of State or inspectors now have a new power where they can dismiss appeals if it appears that there is undue delay to the appeal that's being caused by the appellant. Effectively, they can say to the appellant, you need to have done X, Y, Z in a certain time frame. If you haven't, your appeal's dismissed. And there is also a new power to the Secretary of State where they can, by regulations, say that a local planning authority aren't entitled to enforce certain planning conditions. And I think where that might come from is, you might recall at the beginning of the pandemic, there was a ministerial statement from the Secretary of State where they, in respect to delivery times, where they were saying, well, you shouldn't enforce delivery times to supermarkets because at the time there was a lack of, there was just a lack of resources at supermarkets. So, but that was only a ministerial statement. It didn't actually have legal effect insofar as the local planning authority could, if they wanted to, disregard it and enforce. Now the Secretary of State actually can mandate that the local planning authority aren't entitled to enforce those planning conditions. That's a whistle-stop tour, hopefully, of the issues that might arise after the grant of planning permission.
Killian, I had a question on those, and it was in light of the existing section 73 and 96A that we have in respect of amendments that can be made to planning permissions. Why do you think the government are proposing to introduce the new section 73B?
Yeah, my sneaking suspicion is this might arise out of the Finney and Welsh Minister's judgments. So as you know, there's the judgment which in Finney that they said that section 73 application can only amend the conditions. It can't have the effect of either changing the description of development or making a change that would have resulted in the change of the description. That, I don't know about you, but I have numerous developer clients where that has been a huge thorn in their side, where they do need to make amendments to their planning permission, and which would affect the description of development. Previously, they were using section 73, now they can't. You've got the option open to you of trying to do a non-material amendment through section 96A, but of course, if a local planning authority say no, then you're snookered. Whereas this new power, section 73B, that's the circumstance, I think, where most people will use it, where they want to change the description of development, where you say, well, it's not substantially different, and critically, you'd have a right of appeal.
Thanks, Killian. Thanks, everybody, for that hopefully useful and informative discussion. And that's the end of the webinar. So obviously, if anyone's got any questions they want to ask us, then you can contact us on our various chambers websites. We hope to hear from you. Thank you very much.
Thank you. Bye.
Thanks.